Hi, I'm Tom King, the founder and CEO of Toolkit.law, and as part of our global CLE to the 80 plus countries with English-based legal systems, we're here with my friend, Maisha Colter, who has not testified, but spoken at many of the CLE events that we've put on in our jurisdiction. And we're here, Maisha, to talk about a topic that's important to you and me, which is child welfare and specifically direct and cross-examination involving child welfare cases. Maisha, you're the CEO of ABDA. What does ABDA stand for, and what is your mission statement?
Sure. ABDA stands for Aid to Victims of Domestic Abuse. We help survivors of domestic abuse with free legal representation, and we also educate those who've been identified as abusive in their intimate partner relationships with what's called battering, intervention, and prevention programming.
So we're going to use terminology that may be specific to the United States, but obviously this is targeted at those 80 countries with English-based legal systems. So let's go ahead and jump right into this now. And let's go ahead. We'll take it column by column. I think you and I agree that you'll take the left column and I'll take the right column. What is the top left column? And walk us through it.
So direct examination is essentially questioning witnesses who have pertinent information to your child welfare matter. With direct examination, we're talking to those witnesses who are going to be collaterals. They're going to help to put on the evidence that's going to be persuasive to allow your position to be put in front of a judge or a jury, whoever you are trying your case to. So the first thing you want to do is establish the credibility of the witness that is going to be testifying. You want to make sure that whoever is hearing your facts understand that this person is credible, they have a relationship or a role in the life of the child that's having their case presented. Build trust and credibility. So you're establishing who is this person, what is their relationship to the child that's the subject of the lawsuit, and why are they able to testify to facts that are going to be necessary to help persuade a court, jury, or a judge.
Right. So
Focusing on
obviously you're focusing on things specific to what the judge is looking at, which is the child's welfare, correct?
Correct. Yeah, you want to know, does this person know about the child's welfare, well-being, emotional well-being, their physical well-being? Have they witnessed or had any type of interaction with the parents or anyone who has probably caused them stress or harm? You want to clarify a child's needs and concerns. So you want to make sure that this witness is able to describe what this child is going through and what they may need. A direct witness could be anyone from a teacher, a child care provider, or someone who's had some standing in the child's life that would have relevant information about their well-being. You want to testify, you want them to testify to positive parental behavior. So if they've had an opportunity to observe the parent and the child together, and they know that the parent has brought positive interactions with the child, you want that to be conveyed. You want to be able to know if the parent is proactive around keeping the child safe or out of harm's way. Those are the things that you want that particular type of witness to testify. If there is documentation that supports either the harm to the child or abuse to the child, then you want those witnesses to be brought forth. So in those instances, it could be a social worker, a medical professional, someone who's actually observed the child's injuries that they've sustained as a result of an assault or crime that was perpetrated against them. You want to talk to someone who might be able to talk about the child's emotional well-being. Are they, experiencing anxiety, depression? What is the affect of this particular child after they have sustained the type of abuse that is usually being tried?
Often children will make what we in the American legal system call an excited utterance, right?
Mhm.
Something that
Yeah.
is spontaneous, that is emotional, which is an exception to the hearsay rule, right?
Right.
In
Yeah. So
American jurisprudence.
if a witness was present at the time that the child made some type of excited utterance or an outcry that demonstrated to that witness that the child had been harmed, then you can ask that witness, what did you hear? And they can tell you the child said or the child did something. And in ordinary circumstances, they might get an objection. But because of the way that that child expressed that information at the time, then you get to be able to say that this is an exception to the hearsay rule.
So let's talk about, so obviously in some countries or jurisdictions, the standard is those magic 5 words, right? Best interest of the child.
Of the child.
Right?
Mm-hmm.
It's going to differ, but depending jurisdiction to jurisdiction, but the concept's the same, Maisha, that we want to emphasize that is the legal standard that the judge or jury is using, right?
Exactly. Yeah, we want to make sure that at the end of the day, whatever evidence you are bringing forth to the court is going to help that judge evaluate whether or not the behavior on the part of someone was in the child's best interest or not in that child's best interest. And there are going to be multiple sources to be able to convey and tell a story about what was in the child's best interest and what was not, and by whom. You can ask questions that describe how. Go ahead.
No, I was going to say,
No, I was just going to say,
finish the column. Yeah.
sure. Yeah. So you can ask questions that describe how the family dynamics were, including was there domestic violence or neglect? Has a child witnessed those things? How did it affect the child? How has the relationship between the child been impacted by the trauma or some of the behavior that that child underwent while being in the care of this person or that person? Concluding with recommendations or observing. So observation. So after that witness tells you the story of what they observed or what they heard, then you might be able to ask, depending on the circumstances, if they have any recommendations. Would they recommend reunification between the child and the parent? Would they recommend that the parent's rights be terminated and that this child be placed in a situation where they can be adopted? So those are the kinds of things that those particular witnesses could provide as evidence.
Now we're going to jump to the other side, and you're gonna jump in with your comments as I talk about. We talk about, Maisha was just talking about what comes out of the witnesses, right? Direct examination, witnesses that are positive to us. We want to back that up with evidence that they can validate, right, Maisha?
Sure, absolutely.
So what do we love as lawyers? We love photos. We love videos. We really love social media because no one's ever said anything stupid on Facebook, right?
Exactly.
And so, we want to introduce photographs, we want to introduce documents, but you have to remember to tell your clients how to help you authenticate the evidence. Don't assume that a non-lawyer knows the predicate.
Right. Right.
Right?
And when we're talking about predicates, we're talking about what steps do we have to ask that witness to make sure that they set the standard, that they say, I took this picture, I was present at the time, the picture hasn't been changed in any way, it hasn't been altered. That way we're laying the foundation, we're sticking with the rules of, at least in this country, civil procedures, and then that evidence can be used and accepted by the court to examine for all purposes.
And I want to show something here on this screen, if I could, and that is, if you go to Toolkit.law and you go to our suites, it's called our creative suite. You could call it your evidence organizing suite. If you have audio files to organize, if you have files to convert, if you have images to like blur out a photo of the kid's face, if you have documents to deal with, or if you have videos to edit, we have 20 to 25 audio editing tools. For a lawyer, you don't need to know how to use Adobe Auditions. That's too technical for us lawyers, but we have 25 or 30 audio editing tools. My favorite one here, I once had an audio in which the audio was too low. So if you go ahead and upload the audio file, you can increase the volume up to 500%. Volume. So look at our audio editing tools on Toolkit.law. Look at all these file conversions that we have. Any image file format, different types of PDF file formats, spreadsheet formats, word perfect formats for those old lawyers still listening to 8-track tape music. Okay. Image files, right? If you need to flip it, if you need to do a collage, if you need to blur the face of a child in an image, we have all these image tools. We have all these PDF editing tools and converting tools. And we also have video editing tools for those people who don't want to learn Adobe Premiere. So I do want to point that out. Okay. And so now I'm going to switch to the other screen. And let's go ahead and look at finish this column. So if there are medical records, put those requests in early and make sure they include the document on top that your jurisdiction requires. In America, we call those business record affidavits, right? And sometimes those are expensive or long to get, or it's a legal process to get because you don't have medical releases per your jurisdiction to do it. But get those medical records in.
Yeah, as early as possible. Just like Tom said, for us, we have to deal with HIPAA. Sometimes if you're trying to subpoena records from CPS or Child Protective Services, videos, if there was a forensic, interview, sometimes they will assert themselves and, file a motion to quash. Be ready for arguments to be able to circumvent those motions to quash so you can get the evidence in that will support and help you with your particular case.
Okay, and conversely, that's what I want to ask you. And because you use an American term, what's HIPAA stand for?
That is
Health
health
and information.
privacy. I got to Google real quick because I know what it is, but I don't know what it is. Hold on, hurry.
It must be
put me on the spot.
Well, you used an American term, and we got the other 79 countries that are going, come on, Maisha, come on, Tom.
What's HIPAA, right? Sorry. I'm going to tell you. Give me.
I bet the A is, you'll look it up while I'm working on this. So
Keep
obviously,
going.
if we have written testimony from other witnesses, statements they made to police that are in police reports, anything like that, we want to get those in. Social worker reports, but remember, they can take months to obtain. If there's expert opinion, in many jurisdictions, they're required to turn in a written report in advance. Right. And then you say X in your report, but you say Y here, right? So either you bolster them with their written report if they're consistent, or you use it against them if they're not. Did you find out what HIPAA stood for?
Yeah, so Health Insurance Portability and Accountability Act. And it's just basically federal law that passed that says that they want to protect an individual's health information. So we can't just willy-nilly just get people's medical records. There has to be some protections in place for those. And then you need to learn how to overcome them if you are in a situation where you need medical records to support your case.
And I was not trying to throw you under the bus because I didn't know what it stood for either. So it's all good. Okay. Video and audio evidence. Of course, we love video and audio evidence. If somebody does something on social media, on the video editor in Toolkit.law, you put in the YouTube address, it'll download and convert the file format for you. So we scrape the videos off Facebook, Instagram, and YouTube. So if it's published on those social media tools, we can even download it for you. And we have like 12 different file formats that we can download it in for you to use as your own evidence. Obviously, statements by a child, if they went to the Child Assessment Center or whatever in your jurisdiction, they call those specialists that know how to question children, which they may or may not record or document in written form. Those can be so helpful. And then, of course, prior evaluations or investigations are so important. So, Maisha, we've been talking about those witnesses that are friendly to us.
Yes.
And we've been talking about the evidence that backs up our friendly witnesses. Now let's flip the script. Let's talk about witnesses that are hostile to us.
Sure. So we want to make sure that the same way we wanted to put those in a positive light that were favorable to us, we want to make sure that the credibility of those that are hostile is questioned by those who are reviewing our case. So identify and highlight any inconsistencies between that witness's statements or evidence. So they said, X or Y, but we have other evidence that supports something completely different. And the great thing about cross-examination, unlike direct examination, is you get to say, you did this. You can lead in your examination. You didn't tell the truth when you talked to the police. You hid, you ran. You can do those things in cross-examination to quickly put that person in that hostile light and discount their credibility. You want to question the witness's biases. So examine the witness's potential biases, such as the personal relationship with one of the parties. For example, isn't it true that you have a close personal relationship with a mother and have been involved in her personal life for several years? Or exposing the lack of direct, knowledge. So you don't really know this child. You have never actually met this child. You're here to testify, but you haven't even seen, mom and the child together. The only time that you ever saw them was, again, diminish their capacity to tell a story that's going to be helpful and diminish their credibility by saying they really don't have anything to offer. Why are we talking to this person?
It's funny. I've never seen you in the courtroom, but I can already hear.
I'm fun in court.
I'll bet you were. Oh, I wish I'd seen you in court. But you're as CEO of ABDA.
I don't really go to court anymore. No.
What a shame. What a shame, because listen to you go, girl. I love it. Okay, let's going. Highlighting the limited role.
Right. So we talked about that. We want to make sure that we diminish anything that they have to say by saying they really have no credible evidence. They're not really involved in these people's lives in a substantial way that's going to give us anything of value. Crediting the witness's qualifications. So are they really an expert? You can ask about their licensure. Are you licensed in this way or that way? What kind of research do you do? What kind of work do you do? Oh, so you haven't really done any recent research, or you don't present on this topic. You're not a subject matter expert in this way. So discounting their ability to appear like they know something at a higher standard than the people who are going to be testifying about this case. Exposing contradictory behavior. So pointing out any contradictory behavior exhibited by the witness. For example, despite claiming to be concerned about the child's safety, you did not report the situation to authorities until weeks later. The only reason why you actually made this phone call is because you knew that someone else was going to make it. The child went to school and the teacher was already going to make a phone call. And so you tried to get ahead of that phone call by calling yourself, even though it had been days since the time that the incident happened. So giving them that role and responsibility. You should have did something and you didn't do anything. Demonstrating hostile intention. So asking questions that highlight the witness's hostility, particularly if their testimony is overly combative or inconsistent. For example, you've been involved in custody battle with the father for years. So isn't it possible that your testimony is influenced by your ongoing conflict? You don't like this person. You have your own agenda here today. So you're trying to muddy up this person's, credibility or this person's status as a good parent because you don't like them, not because you've ever actually seen them do something to harm the child or witnessed them doing anything that got them, in front of this court. You have another agenda. So basically using those opportunities to highlight how they're not here to help.
I already don't believe the witness, and I haven't even met him yet. Listening to
They're
you,
a liar, a full-blown liar of no value whatsoever. I don't even know why they even got to get inside the courthouse today.
I'm all in. I'm all in. Finish the column for us.
Sure. Undermining the witness's credibility. My lights just went out. Impeaching with prior testimony. Use prior testimony or depositions to impeach a witness. So if you've deposed this person in the past and now you're here for trial, you can ask them similar questions as those that you asked at the deposition, but now you get to exploit the inconsistencies. Well, when we met 2 months ago, sir, you said X, Y, and Z. Now I heard you testify this morning that it's this. How is it that it was this on this day and now it's something different? It all happened the same day at the same time. So what's different between when we last spoke at the deposition 2 months ago? So you've given them an opportunity to kind of tie themselves up. We really do discount people who can't keep a same story going. All right.
Oh, absolutely. Absolutely. I'm gonna switch to the other column now, and we're gonna go here.
I have to move around because I have motion lights in my office, and so it thinks
Oh,
that I
okay.
disappeared.
Well, that keeps you moving. That
It
keeps you moving,
does.
Abda. So there you go. Okay. So obviously, I'll never be able to put as much great energy as Maisha just did into that left column, right? And on that left column, we were talking about cross-examination of the hostile witnesses. Now, what tools could Maisha use to do that, right? Well, prior inconsistent statements, right? If before, when we were talking about the direct examination witnesses, those that were favorable to us, and we bolstered them with consistent statements, we want to highlight inconsistent statements, whether they're fact witnesses or jumping down 4 boxes to expert witnesses, right? If they have a bias or a conflict, isn't it true that you have this type of special or different or emotional connection or relationship to the individual? I'll never forget, I asked a witness outside in the hallway, "Are you having sex with this woman?" He said no. Then we went in there, we got on the stand, and the other attorney said, "Isn't it true that you have a relationship with this woman and you're currently in a sexual relationship with her?" And he said, "Yes." I said, "Wait a minute. I just asked you out in the hallway if you were having sex with her." He said, "Well, not then when you asked me." I'm like, seriously?
Yikes.
Yeah. Okay. So it must have happened in the car out in the parking lot. I should have said within the last 15 minutes. I don't know. But
Yikes.
make sure when you're talking to witnesses, sometimes the lawyers aren't as smart as the witnesses, and sometimes the witnesses can be really dumb. So you got to say, "Are you having sex?" as in the last month, in the last 2 months, not within the last 15 minutes. And I don't say that to chuckle, but it was something that made me look silly on the stand because I didn't ask the probing questions in the hallway adequate to the person with whom I was trying to communicating, which is the nicest way I can say I could have done better, but doggone it, he was stupid. Okay, criminal history. If the history is relevant and admissible, use it. If it's not, you really need to decide if you want to broach that and potentially ruin your credibility with the judge, right?
Yeah.
If you can look, if I'll give you an example, Maisha. I had a case 2 days ago in which the dad, who is currently a cocaine addict and abducted the child, 15 years ago was convicted of assault of a police officer. Not relevant to this now, right? I didn't bring that up because there's no way it would have been. I can't say he's violent today because of
Right.
something 15 years ago that was a
Yeah.
mistake. And so I had to look myself in the mirror. Do I raise it with this police department? And I didn't, right?
Yeah.
But you do
Yeah.
look at the relevant criminal history, right?
Yeah, absolutely. Yeah. So if you have somebody who's got a family violence assault and you got a child who's been injured as a result of a melee between the parents, it's relevant. This person probably has been violent and volatile in that family dynamic, and that becomes very relevant, and it absolutely needs to be brought to the court's attention.
So we want to look at prior testimony or depositions, right? Prior testimony or depositions. So if there's something in which they are documented in saying X, and today they are saying Y, you want to point out that credibility should go down. It's a pretty overused line, right? Were you lying then or were you lying now? You don't necessarily say it that way because it's a pretty overused, whether you're in Hollywood or Bollywood, all around the world, that's an overused line. But the underlying concept is consistency equals credibility.
Exactly.
Inconsistency undercuts that, right? And
Yep.
expert witnesses. You can shred an expert witness if either they didn't turn in a report, if their qualifications don't match that which they're testifying to, or if they left something out of their report. Oh, well, in your report, I see you didn't cover this topic.
Mm-hmm.
You agree that that's a topic that falls under domestic abuse? Yes. And is this case a case that involves domestic abuse? Yes. And yet your report didn't include that, did it? No. So would you, by your own testimony, agree that your report is incomplete?
Mm-hmm.
Right? Things like that. If
Yep.
somebody has lack of direct knowledge, why are they here? Why are they testifying? You know, before they start testifying in front of the judge or the jury, you have the right in most jurisdictions to say, sir, we're here to talk about events that happen on these dates. But isn't it a fact that you live in a different state and you weren't here and you don't have personal knowledge of it, only of what your best friend told you about it? And she's here in court and you're here to help your best friend, right? So if they don't have direct knowledge, we don't want them to pollute the judge or the jury's, the decider of fact as to what they're going to consider, right? You want to look at their motive for providing false testimony, and we want to look at medical records that might be contradictory. And sometimes this can be so uncomfortable, especially if you're a male talking to a female that's alleging some really potentially horrible stuff, right, Maisha? Because if it's an alleged rape, and if I'm represent the guy and I'm saying, well, ma'am, you're saying this, but in the medical records, I know it's a sensitive topic, but I see this or I don't see this, right? And so those are things that you need to address. Maisha, it's related to domestic violence. And I had something happen 2 days ago, and I've been looking for an excuse to use this. I think you're going to love this story. So 2 days ago, I was with a client. The biological father, who's a cocaine addict, took the child and was hiding the child for 3 days. Filed a report with Child Protective Services, which is in our jurisdiction. You're required to do. Then we walked into the local police department to file it. At first, we were being questioned out in the lobby by a female officer. She went back for 30 minutes. And during that time, I offered some answers. I supplemented as a lawyer and made sure that things were covered. She goes in. 30 minutes later, she comes back out with 2 officers, very big, muscular officers. And they said, ma'am, can this officer go talk to you outside? I'm like, whoa, wait a minute. You're talking to my client without me? They said, sir, just stay here 1 minute. They were so smart. They thought maybe I was controlling her and I wasn't her lawyer. And they were thinking ahead what 10 years ago in the United States we wouldn't have done.
Well, I applaud them for thinking about that. Yeah.
And they should have asked me for my bar number up front.
Something. Yes.
Goes, what's your bar number? I said, I'll give it to you in a second, but you're questioning my client, but it's 00784398. And I went outside. I said, what did you ask her? I just wanted to make sure that you were her lawyer. And I immediately softened and I went back in and I go, you should ask me for my bar card at the beginning, but thank you for asking me.
Yeah, for considering, I
was a bad guy. Isn't that awesome?
That is awesome. That's good. That's good police work. That's good police work and sensitive, trauma-informed police work. That's awesome.
Trauma-informed lawyering and I should have told them, you know what? I should have shown them, here's my bar card and here's my license. Let's put it on me. I should have done that as a lawyer. So when you're interacting with law enforcement or agencies, prove to them up front who you are. And I thought, boy, did I learn something 48 hours ago that man, okay, if you're in America and if you're in Texas and if you're in Fort Bend County, kudos to the Rosenberg Police Department. And to those of you in the other 79 countries and the rest of America, you're not going to be able to thank them, but you can learn from the mistake I made. Take your bar card, your bar council card, whatever you call your bar organization, prove your credentials up front So there, because one time my client interrupted me, I said, "Don't interrupt me." And that officer, she observed, she didn't say anything. She went back, she confirmed the other stuff, but she needed to make sure that my client was safe. And I thought, wow, what an epiphany. What an epiphany for me. Anyway, Maisha, wherever they're anywhere in the world, what resources can they find on your website?
So go to www.avda. We have a wealth of information about
.org,
our
.org,
.org. .org. We have a wealth of information about domestic violence, sexual abuse, resources for our services, and other resources out there, community connected resources. Please check us out, and hopefully you don't have to be a part of what we do, but support the fact that we're doing this particular work. It's needed and necessary.
And so I'm going to go ahead. I'm going to do this for you. I'm going to go ahead and put this
There
up
it
on the
is.
screen. Okay, so there's the website. So if you're looking for batterer intervention, you know what? You may be in a different country or a different jurisdiction, but there's battering resources here. There's educational information that if your country or your jurisdiction isn't addressing this yet, what a great place to start. What a great place to start. And I'm
And
sure if you
we educate people all across the United States and abroad. So please feel free to reach out to me, especially if you want more knowledge about domestic violence awareness, information, interventions, protocols. We're happy to consult with others.
and do you offer online courses?
We do for the battering intervention program. We do.
And so, of course, if you don't have a batterers program in a country, I'll give you an example. One of our countries, one of the 80 with English-based legal systems, Pakistan. I don't know if they have batterers courses there. It's where a lot of our software development team is with Toolkit.law. Maybe you ask the court to approve you taking this course on the ABDA site as a condition of whatever you're trying to negotiate with the court and with the other side. So there, once again, Maisha, every time I've dealt with you professionally, I have learned, I have profited. You've been in our jurisdiction and the near surrounding jurisdictions. You are such a shining light, and it's always such a pleasure to work with you. Thank you. And this
Thank you.
concludes this presentation.